This continuing education program, entitled Sexual Harassment Prevention and Training in the Workplace, is brought to you by the Illinois Council of Health System Pharmacists. My name is Jen Arnoldi, and I'll be your presenter for this program. I have no relevant personal or financial conflicts of interest to disclose, but I did want to say that by nature of this topic, the educational material that I'm about to present contains references to and examples of sexual harassment in the workplace. Some individuals may find this distressing. I encourage you to speak with a mental health professional should you find this material potentially triggering. Our objectives for today's presentation are to describe sexual harassment and its impact on victims in the workplace setting, to examine scenarios that constitute unlawful sexual harassment, to identify federal and state statutory provisions for victims of sexual harassment in the workplace, and to discuss what the employer responsibilities are for preventing sexual harassment, investigating claims, and taking corrective actions. There are many examples of what may constitute sexual harassment. Some examples that we might think of right away would be pressuring someone for sexual favors, or continually asking someone to go out on a date, even when a date has already been refused. Unwanted, deliberate touching of another person is sexual harassment. This includes touching that the instigator may potentially perceive as innocent, such as if a colleague complains about their neck being sore and you try and give them a neck massage. This also includes blocking someone from leaving a situation that they feel uncomfortable with, or cornering them in a threatening way. Sexual harassment can occur without words even being exchanged. Making lewd or suggestive gestures, or gestures that simulate sexual acts, are just a few examples. Sending or sharing materials of a sexual nature is also sexual harassment, whether it's done by email, text, showing something in print, or even just showing someone else something that's on your phone or your computer screen. Other examples of sexual harassment include making sexual innuendo, jokes, or off-color remarks. This can include teasing another person, asking them personal questions of a sexual nature, or calling someone names and using inappropriate or rude terms. Using a term that you might not think is rude, or that you might even call a term of endearment, such as baby, sweetie, or honey, are not appropriate. This is probably a good time to point out that sexual harassment is an issue when the behavior is unwelcome, and it may occur regardless of the intent of the harasser. So the harasser might not actually be trying to cause abuse or mean any harm, such as a colleague who calls another colleague honey. They might not be doing so with a bad intent. However, once they are told that the behavior is unwelcome, they must stop any further use of that type of language. Continued use would be sexual harassment. It is also important to note that sexual harassment may occur irrespective of gender identity or sexual orientation. In other words, anyone can be a perpetrator of sexual harassment, and anyone can be a victim of sexual harassment. Comments about someone's sexuality or their assumed sexuality, their sexual development, or their gender identity are not appropriate. Teasing or harassing someone for not fitting society's ideas of social gender norms is also a form of sexual harassment. With so many examples of what may constitute sexual harassment, you might be thinking to yourself, this could be difficult to classify, and that's true, it can be a challenge. In general, there are three types that we will discuss today. Those are quid pro quo, a hostile work environment, and retaliation. Let's discuss these in further detail in the next few slides. Quid pro quo is a type of harassment that states or implies that if you do something for me, I'll do something for you. In essence, it is made clear that if sexual favors are given, benefits will be received. Those benefits can be something like being given a promotion to a higher job title, being promised a raise, or even something like being promised a better schedule. This type of harassment can also be in exchange for avoiding a negative effect. So a supervisor might say or imply, unless the sexual favors are given, the employee might be written up, given a poor performance evaluation, or receive an unpleasant assignment or schedule. There can be cases where there is a threat made to the person's job, their pay, or other benefits. If a victim of sexual harassment takes their case to court and receives a positive outcome, they may be entitled to damages, and those can include things like medical expenses that are related to the harassment, any economic loss related to their job, and mental and emotional damages. If the employee can show that the employer enabled the sexual harassment, either directly or just by indifference, so being aware of the situation and doing nothing about it, the victim can also pursue punitive damages from the employer. The next type of sexual harassment is a hostile work environment. The creation of a hostile work environment is through the unwelcome conduct of a harasser or harassers that is severe enough to impact the victim's job performance or one that affects the terms and conditions of their employment. What we see most often is recurring behaviors of any kind, particularly after the victim has asked the harasser to stop or after they've made a complaint about the behavior. Someone who makes constant sexual jokes and innuendo in the workplace who has been asked to stop is creating a hostile work environment. A hostile work environment can also exist secondary to a severe event such as a sexual assault. If the victim of a sexual assault is to remain in the same workplace as their perpetrator, that environment can be hostile for the victim even without additional threats being made or carried out. It is also important to note that in today's world, our definition of the workplace has expanded. A hostile work environment can exist outside of the physical boundaries of, say, a central pharmacy or a clinic setting. Harassment can be experienced within any area of the health system setting. It could be up on the nursing floors, in an exam room, or even off-site locations. If colleagues are traveling together in a car or attending a conference together, sexual harassment can be considered taking place in the workplace. Sexual harassment can even happen online through email, messaging, video conferencing, or other electronic means. A key part of the hostile work environment is that the behavior is unwelcomed. So what does that mean, or how would I know that the behavior is not welcome? It means that the victim did not solicit or invite the behavior, and that they perceive it as undesirable or offensive. So sometimes colleagues willingly engage in joking, teasing, even physical touch that they consent to. It might be against employer policy, it might be inappropriate, and it might actually be a bad idea, but it isn't necessarily sexual harassment as long as they're both consenting to the behavior. One important thing to be aware of in a scenario like that is that welcome behavior can become unwelcome if it crosses the line or if consent is revoked. So, if two colleagues who typically make inappropriate jokes with one another find themselves one day saying, I want you to stop talking to me like that. I don't actually like it. Or, I know we were joking, but you took it too far, you crossed a line, and now I want it to stop. Then the other colleague needs to stop, and failure to do so would be sexual harassment. This does place some amount of burden on the victim, but in order to make it clear that the behavior is unwelcome, the victim is expected to speak up or to make a complaint so that there is no room for interpretation. Some other considerations with a hostile work environment are that the harasser or harassers do not need to be in a position of authority over the victim. The harasser can be a colleague, or it could be their supervisor. It could be somebody who works in the victim's own department, or it could be somebody from an outside department. It could even be a patient of the health system or another guest of the health system. It could also be someone who the employer contracts with, such as a delivery person. Due to this, the harassment is not necessarily tied to any real or insinuated benefits or threat of a removal of benefits like we saw in the quid pro quo type. As previously stated, if you are subject to or witness to a hostile work environment, the victim should first tell the harasser that their conduct is unwelcome and that they should stop. The victim can also file a complaint using whatever grievance system is available through the employer. So that might be something like reporting it to the supervisor, reporting it to HR, and there may or may not be forms that need filled out and submitted. The final type of sexual harassment that we're going to discuss is retaliation. So this is any adverse action taken against an employee who has asserted their right against discrimination. So if any employee files a complaint, asks for a certain behavior to stop, reports to HR, whatever the case may be, they may even assist with an investigation as a witness. No matter what occurs, state and federal laws prohibit the employer from retaliating against them. So in retaliation, the employer cannot give the employee bad performance reviews without justification. They can't fire them, demote them, or do anything that changes the terms and conditions of their employment. Now that we have a better understanding of what sexual harassment entails, let's review some statistics on the prevalence of sexual harassment in the US. These data are not necessarily specific to pharmacy or healthcare, but they are pretty sobering nonetheless. One thing I want you to keep in the back of your mind as we review the figures is that these numbers are likely lower than the true number affecting people in our workplace due to underreporting. With that being said, as many as 60% of women say they have experienced unwanted sexual attention, sexual coercion, sexually crude conduct, or sexist comments in the workplace. And again, this number is likely higher than 60%. This is just the 60% who reported it. Over 85% of people who experience sexual harassment never file a formal legal charge. So the majority of people who experience this never take the case to court. Approximately 70% of employees never even complain internally, so they never let a supervisor know or file something with human resources. And I said previously that anyone can be a victim and anyone can be a perpetrator. It doesn't matter, man, woman, identity. One study in 2016 reported that 1 in 7 women and 1 in 17 men have sought a new job assignment, changed jobs, or quit a job because of sexual harassment or assault. That'll lead us into talking about what is the impact that sexual harassment can have on its victims. Victims of sexual harassment can suffer in many ways. Everyone will react differently to harassment or abuse. Some of the possible emotional or psychological effects can be onset or worsening of depression or anxiety, feelings of anger or betrayal, and this could be towards the harasser, to the supervisor or employer, or the trusted individuals that were around when the situation occurred. The victim can feel shocked that this has happened, confused, and unfortunately, some may feel a deep sense of shame. There may be some physical health consequences related to this as well. Victims of sexual harassment have reported experiencing sleep disturbances, and that includes having nightmares. Some victims may also develop panic attacks or panic reactions, especially when being placed in circumstances that remind them of the harassment or the assault. Now, these are all significant enough, but victims of sexual harassment can also be impacted professionally. It could be that the symptoms that they're experiencing secondary to the assault could lead to things like absenteeism. So if I'm having significant enough sleep disturbances that I'm not getting rest, or that I'm significantly affected by panic or phobia when I come into the workplace, that might result in absenteeism. Folks coming to work after experiencing sexual harassment may find themselves withdrawing from social situations at work, losing interest in the activities that they should be doing at work, not being able to focus on patient care and other activities, and an overall loss of job satisfaction. With that in mind, let's take a look at our first case. We have Casey, a PGY1 pharmacy resident at a large academic medical center. The preceptor Casey is assigned to is on vacation right now, so Casey is being supervised by another pharmacist, Alex, for the week. Alex has made some suggestive jokes to Casey. They've made a few flirtatious comments and asked about Casey's relationship status. For the most part, Casey has just tried to ignore this. At the end of the day today, Alex suggests, let's go out for drinks and see where the night goes after that. Casey turns down the invitation, saying, I've got a lot of project deadlines and I have a lot of things I need to get done at home. Alex says, well, that's your decision. Just remember that when your preceptor comes back from vacation, I have to give them a report about your performance. I'd hate to say that you were standoffish and not a team player. It's really not a good look for a new resident. So please take a moment to reflect on this case and think about how you would answer the questions on the screen. So first of all, what makes us believe that this is unwelcome behavior? Well, from what we review in the case, it doesn't seem that Alex's, jokes, flirtation, asking questions about relationships, and then that final invitation that included the innuendo. It doesn't seem that that's being invited or welcomed by Casey in any way. In terms of what type of sexual harassment I would label this, I would tend to think that this is a quid pro quo harassment. It's that you do something for me, I'll do something for you. Or if you don't do something for me, this is the consequence that you're going to face. There's a misuse of power here by Alex, who's in a supervisory position to Casey. Alex heavily implies that Casey is going to be given a bad report about performance to the primary preceptor if they don't go out for drinks and see where the night takes them. So that power dynamic is important. And in the second question, things that stand out about the nature of the harassment and what might make Casey hesitant to report it, I think largely comes from that position of authority and power dynamic that makes Casey feel like they might not have the power to do anything about this situation. Casey is being placed in a position of having to choose between maybe having their performance evaluation affected, and that could jeopardize their place in the residency or in the health system, and maintaining personal comfort and integrity. I wanted to use this case to highlight some data that I found regarding pharmacy learners. In our previous case, our pharmacy resident Casey was being harassed by Alex, a pharmacist who was in a supervisory position for the rotation. Trainees and learners, such as students and residents, are uniquely vulnerable to harassment and mistreatment. In healthcare, learners have been found to encounter harassment more frequently than their established colleagues. That harassment can come from other colleagues, including their supervisors and preceptors, and it may also come from patients. Learners have reported feeling hesitant to come forward with concerns about sexual harassment. Learners tend to be young and may have less life experience and less work experience than their more established colleagues to be able to draw on and know what to do. So they might use techniques against harassment that are not very effective. So some learners may try to just ignore it or turn it into a joke. The power dynamics involved with learners make the situation complicated. So learners are hesitant to sort of rock the boat and they don't want to create an issue. So they may try to just go with the flow and avoid anything that might jeopardize their grade, make it seem like they're burning a bridge, or just give them a bad reputation. Additionally, learners may rationalize that they're not going to be in the situation for very long. They might say to themselves, I only have 3 more weeks left on this rotation, and then I'm not going to have to deal with this person anymore. So I'm just going to put up with it, keep my head down, and then move on when it's time. I wanted to bring this up to encourage us all to be vigilant about protecting our learners. This is a situation where we cannot expect them to be the ones to take the lead. If you are in a position of being a supervisor or a preceptor, your vigilance and your response to any incidents are critical. Silence or doing nothing implies consent or approval of the harassment. Thinking about the last case might have you wondering about the legal frameworks in place to protect victims of sexual harassment. There are protections in place at the federal and state levels. Let's discuss these in more detail on the next few slides. Today's legal framework started with the Civil Rights Act of 1964, specifically Title VII of the Act. This act protects employees and job applicants from employment discrimination based on race, color, religion, sex, pregnancy, and national origin. Employees and potential employees are protected against discrimination based on these factors at every step in the employment process, all the way from recruitment through termination. The Act also created the Equal Employment Opportunity Commission, or EEOC, in order to enforce Title VII. The EEOC began its work in 1965. Over time, additional protections were written into the Act as amendments. For instance, pregnancy was not originally a protected group in the original Act, but it was added later as an amendment. In 1972, Congress gave EEOC the authority to file lawsuits against private companies for Title VII violations. Prior to this, they acted in more of an advisory capacity. In 1990, the Americans with Disabilities Act, or the ADA, was signed into law, and Title I of the ADA prohibits discrimination against people with disabilities in employment. I mention this because EEOC was also given responsibility for enforcing Title I of the ADA. And if you are looking at the list on the screen of the protected categories, you might have been wondering to yourself, what about folks with disabilities? So I did want to mention that they are protected under the ADA, which is a separate act. In 1991, the Civil Rights Act was amended to give employees the right to request a jury trial in Title VII and ADA lawsuits. This was done to try and make the process more fair for victims of sexual harassment, and it also allows successful plaintiffs to recover damages in intentional employment discrimination cases. I also wanted to point out here that the EEOC and the Civil Rights Act Title VII applies to employers in public and private sectors, and those that have 15 or more employees. We'll talk a little bit about this in the state of Illinois protections as well. So the Civil Rights Act and the EEOC protect us at the federal level, and in the state of Illinois, we also have the Illinois Human Rights Act. This act makes sexual harassment a civil rights violation and prohibits employment-based discrimination, harassment, sexual harassment, and retaliation against individuals. The figure to the right shows protected classes in Illinois, and you can see sex, gender identity, and sexual orientation are a part of those protected classes. In addition to the Illinois Human Rights Act, the Illinois General Assembly has stated that sexual harassment in the workplace creates a hostile work environment, reduces productivity, and increases legal liability for employers. The state encourages employers to adopt, implement, and enforce policies leading to a safe environment free from sexual harassment and retaliation. Now that we're aware of the legal protections in place for victims of sexual harassment, let's drill down to the rights of victims and what should be done if one experiences or witnesses sexual harassment in the workplace. First, the victim has the right to tell the harasser to stop, and then the harasser must stop the unwelcome behavior. As I mentioned earlier, this does put some burden on the victim, but it is helpful in circumstances where the harasser might try to claim that they were not intending any harm. We don't want them to be able to say, "Oh, I was joking, you shouldn't take it so seriously," or "I didn't mean it like that, you misunderstood." By explicitly stating that the victim wants the behavior to stop, any continuation of the behavior is then clearly a violation. Victims and witnesses have the right to report harassment. Often, there are internal processes for reporting cases of sexual harassment through the employer. There should be policies and procedures in place in terms of who to report to and how to accomplish that. There are also reporting options through the state and federally through the EEOC. The reporting method chosen is up to the victim or the witness and may depend on the nature of the harassment. A victim may choose to only report to the employer, and they may be satisfied with the results that the employer does with their investigation and any corrective measures. A victim may opt to report directly to the state or even escalate it to the federal level. In any case, no matter what mechanism is chosen, the victim and witness are legally protected from retaliation by the employer. In Illinois, here are some of the reporting options available. Again, reporting through the employer should be available. We can report through the state, And there's also a sexual harassment hotline available to help people decide what actions they should take. Reporting is done through the Illinois Department of Human Rights, and then the EEOC has the reporting mechanisms to be done at the federal level. As I mentioned, Illinois has a sexual harassment and discrimination helpline. You can contact the line using the toll-free number on the screen, and you can also visit illinois.gov/sexual harassment. When contacting the line, there are various helpline representatives who can help a caller navigate what the reporting options are and can also provide additional information related to obtaining mental health counseling, how to obtain and retain legal assistance, and any other frequently asked questions that are experienced by victims of sexual harassment. It could be that calling the Illinois helpline would lead to them referring the victim to the Illinois Department of Human Rights. So as I stated, the Illinois Department of Human Rights is the avenue which a victim would pursue to report a charge of sexual harassment. Victims may file a charge at any time as long as it is within 300 days of the incident. I want to point this out so that victims of sexual harassment can be aware they don't need to file a charge or make their report right away, but there is a limited time frame with which to do so. So it has to be done, as I said, within that 300-day time frame. If the victim decides that they want to file a charge, they must submit a complainant information sheet to IDHR. And we'll talk about that a little bit on the next screen. I also wanted to point out here that the Illinois Department of Human Rights has jurisdiction over employers in the state of Illinois, regardless of the number of employees that the business has. So on the previous screens with the EEOC, I showed that they have jurisdiction over employers with 15 or more employees. But if you're filing at the state level, it doesn't matter the size of the business. You can reach IDHR by calling the toll-free number on the screen, looking online at illinois.gov/DHR, and there are also 3 physical office locations, one each in Chicago, Springfield, and Marion. I pulled a screenshot from the IDHR complainant information sheet. This is only one small part of the form, but this is the part that involves sexual harassment claims, so I wanted to walk through this. If the claim involves sexual harassment, you can see here on the form that they would like to collect the name and job title of the harasser. The form then asks the victim if they want the sexual harasser charged separately as an additional respondent. So this is asking whether the victim wants the harasser named separately or if they only wish to pursue charges against the employer. If the victim does want to charge the harasser separately, they should provide as much contact information as they are able to obtain. In the next box, the form asks the victim to describe the actions that were taken against them, including the dates or approximate dates that anything occurred. Again, we are working within that 300-day time frame. They list some examples of what might constitute sexual harassment, and they also recognize that additional room might be needed to be able to describe everything that happened, so the victim is able to attach an additional sheet if needed. Following that, the form asks the victim to describe whether the conduct was welcome or unwelcome. If you recall, we discussed what makes behavior unwelcome, and that it was not invited, and it was found to be offensive. Remember, I recommended that victims let the harasser know that the behavior is unwelcome by asking them to stop. So the form is asking if the behavior was unwelcome, how did you reject the conduct or make it known that it was unwelcome? And they ask you to describe that here. The final part of 7A is that if your complaint includes some action that was contingent upon submission to the sexual conduct, were you told what would happen if you did not submit? So I feel like this is worded a little awkwardly, but what this is getting at is that quid pro quo type of harassment. So if you were promised that if you submitted to the sexual advances, that you would receive something in return, or that if you failed to submit to the sexual advances, that there would be some consequence. What was told to you or what was implied? Who said it, and when did that occur? Once the IDHR receives the completed complainant form, they will complete its investigation. At the end of the investigation, they will find whether or not there is substantial evidence of a violation. The victim has the ability to either file a lawsuit in civil court or to file a complaint with the Illinois Human Rights Commission, the HRC. Victims who are successful with either complaining to the HRC or filing a lawsuit in civil court may be entitled to compensation under the Illinois Human Rights Act. So these are things like receiving back pay, reclaiming lost benefits, having any negative documentation cleared from their personnel file, mental and emotional damages, reinstatement if they were removed from their position, and assistance with attorney fees and costs. At the federal level, then, instead of the IDHR, the complaint would be made with the EEOC. IDHR and the EEOC are consistent in that victims of sexual harassment may file a charge at any time within 300 days. If it's been beyond 300 days, they will not investigate a claim. The EEOC has jurisdiction to investigate employers with 15 or more employees, and the process can be started by calling the toll-free number or visiting eeoc.gov. Similarly to IDHR, once they've received the complaint, they'll initiate an investigation. The EEOC then determines whether they find reasonable cause that sexual harassment has occurred. The victim's options are to file a lawsuit in federal court or to work with the EEOC to help reach a settlement through a process called conciliation. This is to avoid having a case go to federal court. If the case does go to court and the victims prevail, some of the compensation discussed on the previous slide is also available to these victims. Let's take a look at another case. In this case, we have Blake, he, him, a pharmacy technician working in a centralized hospital pharmacy. Blake has previously made several reports related to two of the pharmacists on his shift who regularly engage in offensive sexual banter and innuendo that make him uncomfortable. Recently, Blake has asked them to stop talking like that around him. They brushed him off and said he was too sensitive. Since then, they continue to make jokes and use innuendo, but then they will loudly add, "Oops, I shouldn't say that around Blake. We all know he has no sense of humor." Blake mentions this to his supervisor, stating that he feels he's being singled out. Nothing is addressed, and the behavior continues to worsen. Blake is actually starting to dread going into work every day and begins looking for a different job. So again, I'd ask you to please reflect on this case for a moment and think about the questions on the screen. And let's talk about what type of sexual harassment we think this is. So there are repeated inappropriate comments and behavior, and that seems to be pretty pervasive and is even getting worse. It does seem to be affecting the workplace atmosphere for Blake, and it's going on despite him having asked that to stop and having reported it to the supervisor. So I would classify this as Blake is experiencing a hostile work environment. What impact is this having on Blake? Well, we're told in the case that he actually dreads coming into work and is looking for a different job. This means that it's probably affecting him quite a bit in his mental well-being and could be affecting his on-the-job performance as well. So the steps Blake has already taken, which are great, is that he has directly asked the abusers or harassers to stop, and he has let them know that he's not comfortable with their behavior. He's also mentioned it at least a couple of times to his supervisor. It's not really clear from the case whether this was done in a formal process or if maybe Blake just said something to the supervisor. Either way, the supervisor should have started to take steps to improve things at the workplace, but they haven't. So what can Blake do next? So one would be to further investigate the policies and procedures for reporting sexual harassment at his workplace. We know that he's talked with the supervisor, but is there something else he can do? Maybe report directly to human resources, somebody who is at a level above his supervisor, or maybe there's a formal complaint process that needs to be filled out and documented. Blake could also call the Illinois Sexual Harassment and Discrimination Helpline. Those helpline representatives could help Blake figure out what his next steps could be, and they would probably refer him to IDHR to consider filling out a formal complaint, which would initiate an investigation. We've reviewed 2 cases of sexual harassment so far, one of the quid pro quo type, and one with a hostile work environment. You may be asking yourself, what is the employer responsibility in these cases? What should the employer be doing? In the next few slides, we'll discuss what employers should be doing to prevent sexual harassment, investigate claims, take any corrective action, and cultivate a culture of safety and respect. To prevent sexual harassment, there should be a number of things in place, starting with clear and easy to follow policies and procedures. So if these don't already exist, they need to be developed, put into place, and clearly communicated with employees. There should be training provided for managers and employees so that there's no question of what needs to be done if an event arises. There should be clear communication on how to report an incident and what to expect after an incident is reported. The employer should also proactively monitor the work environment. So everybody is trained and on the same page about what they should be doing, but what is actually occurring? Are there jokes and innuendo that are kind of tiptoeing on the line of appropriateness? Leadership should be encouraged to keep an eye on things, be aware of what's going on, and they should also be the ones leading by examples. So our managers, supervisors, and other leaders should be the professionalism example, setting the standard that their employees should be able to live up to. If there are any complaints made about sexual harassment, the employer should immediately respond to any of those complaints by launching an investigation. The investigation should include interviewing any involved parties. So getting an account from the victim, and once you know what has happened from the victim's point of view, taking any reasonable actions to protect them from retaliation or further harassment. In a case where the harasser is the victim's supervisor, it may be necessary to shift some workplace responsibilities, shift over obligations such as performance reviews, until the investigation at least is completed. If it's something like a hostile work environment, the situation might call for, again, shifting some responsibilities, changing schedules, or taking corrective actions with the alleged harassers. The investigation should include interviewing all relevant witnesses who may be able to provide insights into what occurred, and interviewing the alleged perpetrator. Any results of the investigation should be documented in the appropriate employee records. After the investigation has been concluded, it is an opportunity for the employer to take any necessary corrective measures. If sexual harassment has been found to have occurred, it is likely that disciplinary action will be needed. This could be termination of employment where there's been a violation of policy. So if someone has been found to have conducted sexual harassment, it might be that that situation leads to them being terminated. If it's found that there has been conduct that's questionable, but doesn't constitute sexual harassment or doesn't violate company policy, it may be that the employer could consider providing counseling, further training, and supervision of the person involved. It's also a good time to take a step back and look kind of at the system level and look at our quality assurance. So what was it within the company culture, policies, procedures, etc., that allowed the environment for this to happen? Do the policies need updated or recommunicated with the workforce? Maybe the policies that exist on sexual harassment are sort of outdated and there are newer circumstances such as, electronic communications that aren't being covered in the policies as they stand. It might be a chance to provide updated or tailored sexual harassment training depending on the situation that was involved. It may be necessary to restructure the working environment or reporting relationships depending on who was involved and what took place. And finally, the employer should always be following up with the victim to ensure that their needs are met. For instance, if something is restructured or a schedule changed, is the victim satisfied with that outcome? And how are things going for them in the new setup? The last case that we'll review together is Holly, she, her, who's an ambulatory care pharmacist. She's completing a new patient appointment with an elderly male patient. He makes some unwanted comments about the way she looks and about her body during their visit. She tries to ignore this, and then the patient makes a sexual advance. Holly tells her supervisor, who suggests that, the patient actually probably meant it as a compliment. You should feel good about that. Not quite satisfied with that, Holly brings her concerns to the clinic manager, who says, oh, that's just the way of the generation. Just try and ignore it. Despite this, Holly requests that the patient not be scheduled with her in the future. At Holly's next performance evaluation, she's given scores that indicate poor performance in multiple areas. She's confused by this because her patients have good documented outcomes, she has high patient satisfaction scores, and she's really never been given any feedback about things like being a team player or specific areas where she needs to improve. So I'll ask you one last time to please think about this case and the questions on the screen. And let's discuss first what type of sexual harassment we think this is. I would say that this appears to be a case of retaliation against someone who has made a complaint. So after complaining about her interaction with the patient and asking for him to be removed from her schedule, she's sort of brushed off by two people in positions of authority. She's even told she should take it as a compliment, and excuses are made. Following that, she's given a poor performance review that could be unjust. It sounds like the performance review doesn't really match up with her current performance in her role. So it seems like that could be in retaliation for her making the complaint. It's not specifically mentioned in the case, but the performance review could be tied to other benefits, such as being able to receive a promotion or a pay raise. So there could be some financial implications for Holly in this case. It's important for us to know what protections are in place for her. So as we previously discussed, the Illinois Human Rights Act and Title VII of the Civil Rights Act protect her at the state level and federal level, respectively. And what are the employer's responsibilities during this? The employer has a responsibility to investigate Holly's claim of retaliation and take any corrective actions needed to protect her. This may include, if it's not already been done, removing the patient from her clinic service or removing the patient from the clinic. And there needs to be some corrective action with the two supervisors who ignored her claims and possibly retaliated against her. Based on this case, it would be a good chance for the employer to step back and see what room they have to optimize their culture of safety and respect. Do their policies and procedures need updated? Do they need to provide some updated training, etc.? I wanted to add another case highlight in regards to this case, where we talk a little bit about patients as harassers. And this is unfortunately a reality that we face in our roles as pharmacists, pharmacy technicians, as healthcare providers. So healthcare providers are placed in situations that may leave us vulnerable to experiencing sexual harassment, and that includes during patient care. Sometimes we are placed in physical proximity with our patients or their caregivers and form an emotional connection with them that is part of the therapeutic relationship. While that relationship should be built on trust and mutual respect, it can create this sort of illusion of intimacy that patients or their caregivers can misinterpret as something more. There may be patient factors that further complicate the situation. So sometimes folks with severe mental illness or dementia or other behavioral disturbances, they may have more difficulty interpreting social relationships and social situations, and they may have issues with impulse control. There may be another factor at play, which is that the patient may perceive a power imbalance between them as the patient and the pharmacist or pharmacy technician as their healthcare provider. That can leave the patient feeling vulnerable and that they want to do something to, in their mind, correct the power imbalance. That may result in them resorting to harassment or abuse, which in their mind sort of levels the playing field. That leaves the provider vulnerable. As you might imagine, patient harassment of a healthcare provider can have many impacts. We previously discussed possible impacts of the victim or on the victim, and those are those things like those mental, psychological, emotional type of damages, as well as the physical consequences that go with that. There's also the fact that once this patient-provider relationship has been strained, if that relationship continues, there's a negative impact. So providers have reported interacting with patients more coldly, so not being as warm as a provider, shortening the visits with patients, spending as little time with them as possible. And part of this might be avoiding open-ended questions and avoiding certain examinations, especially physical examinations. So they're really trying to do as little as they can. They don't want to encourage any negative interaction and just get out of there as soon as they can. And as you can imagine, that would have a negative impact on patient care. So we as the provider might not be able to catch things that we should be catching, and we've really lost that therapeutic relationship. These types of interactions can also increase that power imbalance that might be felt by the patient, so it presents a continued risk of harassment for the provider. Just kind of a takeaway from this, I don't have a magic button or a perfect solution, but I just wanted to point it out that the unique dynamic of provider-patient relationships and some of those ineffective coping strategies that are commonly reported by providers show us that sexual harassment is definitely a complex problem that we know is occurring in healthcare, and that we as providers can struggle to figure out how to resolve and manage these. We may need to focus on additional training, further resources, and organizational support for this in the future. Though there's not a lot of objective data on this topic, the combination of these, ineffective strategies, and we're already in a well-being crisis, and we're looking at our patient outcomes, there's definitely some work to be done in this area. To wrap things up, I just want to summarize that sexual harassment may be classified as quid pro quo, retaliation, or a hostile work environment. There are significant mental, physical, and financial impacts to victims of sexual harassment. There are state and regulations in place to provide legal protections to victims. Employers have many responsibilities to prevent and respond to allegations of sexual harassment, and that together we can all collaborate to foster a safe and respectable workplace that's free from sexual harassment and retaliation. My references are here and in your handout, and I want to thank you for your time and attention.